Mr. Hannafy, good morning.
Good morning, Your Honor. May it please the Court. The case is here on a reservation and report and an agreed statement of facts that speak to the history of initiative amendments, at least during the past 25 years. In relevant part, the agreed statement identifies a series of legislative initiatives that have successfully been processed by the joint session. And it identifies that in the last 25 years, 5 of the 6 citizen initiative petitions failed to be processed by the joint session.
Mr. Hannafy, why isn't this case governed by our decision in the limits case?
Your Honor, as I read limits, I think it is one in a series of cases where the Court was endeavoring to exhibit judicial restraint with respect to the activities of the joint session. In limits, the governor still had residual power to affect the session and to call the session back into order. In these circumstances, we have a session in existence which is in recess, thereby avoiding the necessity or the ability of the governor to call them back because they're already there. We also, I think, have demonstrated, both in our petition and otherwise, that the expectation of the Court that this kind of a problem can be solved at the ballot box.
Mr. Hannafy, may I interrupt you to
Yes, Your
answer
Honor.
this question? I want to turn to your request for relief. At the conclusion of your brief, you ask simply that we declare or confirm the nature and extent of the duties of the defendant presiding officer. In your main brief, however, you ask that we direct the Senate President and his ministerial non-discretionary functions to actually take some action. What exactly is it that you are looking for here?
We are looking for 2 things, Your Honor, before January 2nd. First is a clarification and a statement by this Court as to what the constitutional mandate is under Article 48.
Well, I intend to ask the Attorney General about that, but I thought that there has been a series of cases of this Court that make clear what the duty is. Is there some lack of clarity as to what the duty is?
I believe so, Your Honor. I supplied to the Court and to the Attorney General just a random sample of statements that have been made by lawmakers, some of which exhibit an understanding as to what the duty is, many of which exhibit a misunderstanding as to what their obligations are with respect to final action.
Well, we've alluded to it in several cases, but
Yes,
never
Your Honor.
really squarely said this is what is required. Is that
I
fair,
agree
sir?
with that, Your Honor, and I think that's what we're asking for here. There is a repeated chorus in the brief.
Well, Mr. Hannafy, aren't you speculating that the legislature will not act? How do we know what they're going to do?
Well, Your Honor, I think every case that at least I've read with respect to this article shows the Court's indulgence towards the legislature, but the record confirms that there is a repeated and continuing avoidance of constitutional obligations under Article 48. It's not subtle, it's obvious, it's calculated, and given its repeating quality, I don't think that we're required to see our case turn moot on January 2nd before asking the Court to take some action.
Could I follow up on that a little bit? Suppose we clarify the law along the lines, if it needs clarification, along the lines such as you propose, that they should assemble and take a final vote. And suppose the Senate President, who's the presiding officer, says, well, that's fine. Most respectfully, I'm going to run my institution. The Court is not going to run it. I will not do what we said or what you want them to do. What do we do then? Do we lock him up, find him in contempt?
Well, I think in the first instance, Your Honor, a careful disclosure with no ambiguity as to what the law is a prerequisite to a resolution of this problem. One hopes that when that happens, there begins an institutional habit of faithful compliance with the law.
Well, didn't we say in the limits case that they're supposed to vote?
Well, I agree with what Justice Cordy said, that it is it is not clear from these cases the affirmative obligation of the joint session. What comes through in the cases, with all due respect, is an emerging and overwhelming sense of judicial restraint, which I think has been appropriate until now.
Well, that's one way to describe it. The other way to describe it is genuine ambiguity in the words of the Constitution. I do not take the Attorney General's brief as saying it's clear what the constitutional duty is, but there's nothing you can do about it. That is anything but what his brief is saying. I think that the Attorney General is saying you can't have any relief, but that doesn't go to the question as to whether or not there needs to be a clarification of what the constitutional duty is.
I agree, Your Honor, that his brief, if this was the gist of your meaning, concedes that.
Well, I don't think it does concede, and I intend to ask him about that. I think that it is not inappropriate, for example, to say in certain situations you don't have to decide the underlying merits of the case because there's no available relief. That's a perfectly permissible way to argue. Another way to do it is to say whether or not there's access to any relief, it is certainly the duty of a court to clarify or to state what the Constitution means. And
that's
that,
right.
It seems to me, doesn't in any respect, slanch on the separation of powers or any other such thing. We have done that repeatedly.
I agree with that, Your Honor. But I also agree that with the sentiment that the previous cases haven't articulated clearly the constitutional mandate.
So to go back to my first question
Yes.
to you, I take it that if we declare, determined, or confirm the nature and extent of the duties, and I'm here quoting from your brief, that would be sufficient, because you've also asked that jurisdiction be reserved. Well, that's a different issue. But
I think at a minimum, the president of the joint session ought to be obligated to notify the members of that declaration, so that there is at least he serves as a notice giver as to what the constitutional obligation is. I don't think our petition nor our brief suggests that he can force a vote by anybody. And we recognize the rules and how they've been applied, regrettably.
But you say in your brief that they shouldn't be allowed to avoid a final vote by any procedural manipulation. What if there's a vote to table, or what if a quorum doesn't show up?
Your Honor, the unique circumstances of this case are such that there is no more time.
So what if a quorum doesn't show up on January 7th?
Then apparently there'll be no vote.
So if they vote to table, what can be done about that?
I don't think this court can do anything about that.
Does the Constitution actually require, does it expressly require a final vote, or does it simply say that a final vote is needed to move it to the next stage, which is to get it to the voter?
We believe it requires a final vote. And
But that's an opinion. You don't. Does the Constitution expressly state that they must vote?
The constitutional provisions use throughout the word "shall," and in context, given the 1/4 vote requirement.
But it also says if they do receive 25% of the vote, then it will be certified to the secretary, who will place it on the ballot. But if you don't get the 25%, I take it that could be for whatever reason.
That it won't pass.
It dies.
That's right. But the proposition that you can...
Justice Spina's question was for any reason, i.e., if, for example, the vote is tabled, I take it, Justice
Yes.
Spina. Not that a vote is taken and fewer... There's no question that if a vote is taken and fewer than 25% vote in favor of sending it forward, it dies, correct? There's no ambiguity about that.
Right.
Justice Spina's question is a different one. If there is a vote, not on the merits, but some perfectly non-contrived, regular procedural vote, that it be tabled, where is it in the Constitution that says that vote is somehow unconstitutional?
I don't think it says that, Your Honor.
But it would be totally inconsistent with the whole purpose of the amendment
Exactly.
from the beginning.
Exactly, and this speaks to the issue about the ballot box accountability. It is incredibly difficult for voters to know or understand why, with this phalanx of voting rules, somebody is motivated to vote a recess or an adjournment or whatever else they can vote to avoid the disposition of these motions. And the suggestion that there's a remedy at the ballot box under these circumstances, I submit, is unrealistic, and time has proven that it's unrealistic.
Well, it may be unrealistic, and that may be a serious problem, but it's a separate problem from what the Constitution requires. We all, judges, legislators, members of the executive branch, take an oath to uphold the Constitution of the Commonwealth as best we can, as best we see those obligations. And I take it that your first request is that we make it as clear as we can in our role, that is, to interpret the Constitution and what it requires, so that others who are faced with this decision can understand what at least the Constitution requires, and then they can make their own judgment as to whether or not they wish to comply with it.
Exactly, Your Honor. And we indulge the same presumption that the framers of this article did, which is if people understand clearly and from an authoritative source what their obligations are, we can assume that they'll exercise them in good faith. But I think
Isn't that precisely the issue that was presented in Citizens for a Competitive Massachusetts, and this court decided that, in fact, because there was no remedy, there should be no statement as to what the constitutional duty was? That's not limits, that's citizens.
The suggestion, I think, Your Honor, that there's no remedy here is troubling because it leaves the people with a constitutional right which wasn't delegated to the legislature but was preserved to them in this article.
What is the remedy? I mean,
I think
going back to my, somewhat strained example, we can't find the Senate President in contempt, can we?
No, Your Honor.
So what is the remedy?
I think the remedy is to clearly declare the law and to instruct those who have to follow it as to what their duties are. And borrowing the presumption of the framers of this article, one hopes that that would be sufficient in and of itself to motivate appropriate conduct.
But what is the purpose of that? As Justice Graney has repeatedly asked, if we state what the law is, which arguably we have already, but if perhaps we haven't made it clear enough, we make it clearer now, and we can accomplish nothing as a result, what is the purpose of that?
Well, I don't think, Your Honor, any of us should embrace the conclusion that this Court's declaration of what the law is and should be will be treated with indifference or...
Well, I take it that part of at least the late submissions that you have made is that there are legislatures who publicly say that they do not believe that the Constitution requires them to vote.
That's right.
Am I correct?
That's right, Your Honor.
So let us assume that every single elected representative, as I do, intends to faithfully uphold the Constitution. If there's ambiguity about that, somebody has to declare what the Constitution requires.
Correct, Your Honor. And I would hope this Court would do it to avoid the ambiguity that is evident in those public statements that legislators have made. And I would deal briefly with the question of political question, which has been raised as an excuse not to act on this. I think this Court has, for forever and a day, undertaken to declare constitutional rights, and even in the face of close areas where there are potentially political questions. I don't think there's one here, because we're not asking you to tell the legislature how to do its business. We're asking you only to declare what their constitutional obligations are. We understand how the rules work. We understand, as I think the President of the Senate himself concedes in this brief, that the 1/4 requirement of Article 48 has functionally been transformed into a majority requirement, which means that a large number of initiative petitions that the framers would have expected to have been processed now don't reach that point in time at all, so that voters are left to deal with the ballot box question under circumstances where they don't know why people voted the way they did. They'd have to replace a majority of the legislature, because effectively the legislature is imposing a majority requirement or writing it into Article 48. And it leaves a situation where citizens...
Mr. Henry, I'm not quite sure I'm with you. Why would that be the case? I mean, why would it would be perfectly permissible for people to say, do you believe that if elected you will ensure that a vote is taken, a vote on the merits of any initiative petition to amend the Constitution?
Well, that's a fair question, but I think in the absence of a political circumstance, it never receives the requisite attention necessary to derive political interest at the ballot box.
But maybe that's the answer then.
What is, Your Honor?
That if people aren't interested enough, they aren't interested enough to change their legislators who don't vote.
Well, I think the problem is that we would need to have a majority of these legislators changed. And this amendment was calculated to allow minorities who had compelling interests that a quarter of the legislators believed deserved attention to reach the ballot box. When you convert it to a majority rule, you change the whole dimension. And you not only obscure the opportunity to reach the ballot box, but you take those minority interests and require them to essentially become sufficiently majority interests to have any political effect.
But didn't the framers know that was entirely possible?
Well, they contemplated this, Your Honor, and in the historical record, it indicates that the framers believed, I think, as all of us would like to, that legislators would act in good faith and do their duty, and that...
and that it was almost inconceivable that they wouldn't.
Exactly right. And I also submit, Your Honor, that nothing in the legislative history writes this court out of a declaration of constitutional interests. Thank you.
Mr. Hannafy. Mr. Sachs?
Thank you, Your Honor. Peter Sachs, Assistant Attorney General for the Secretary and the Senate President. The drafters of Article 48 expected, and this Court confirmed in the Limits and League of Women Voters case, that the joint session should vote on initiative amendments, and that if they didn't.
Should?
Yeah, and the court
Constitution
in Limits
requires it?
this Court in Limits and in League of Women Voters used quite clear language.
We've been pretty clear about this.
I
There's
think
no
so.
need to clarify anything.
I think so, and certainly as far as a declaratory judgment goes, Article 30 and Article 21 do not permit this Court to enter a declaratory judgment, and I hear plaintiffs...
But we apparently are now confronted with some legislators who, however much we think we've been clear about it, don't think we have been. And we may say something in a case, but if people are not appearing to have read it or understood it, sometimes we need to say it again and more emphatically.
Well,
Indeed, there are constitutional scholars I've certainly seen, you can't help but notice, who've opined that the Constitution doesn't require such a vote here in Massachusetts.
That's possible, and this Court is obviously free to say what it wishes to say in an opinion. What plaintiffs ask for in terms of relief, a declaratory judgment, is not permissible, and I hear them abandoning their request for mandamus relief.
As far as you're concerned, the Limits case makes clear what they're supposed to do, so if we make it more clear, that's okay with you.
I think the Limits case made it clear, and the League of Women Voters case made it clear.
Your thrust is there's no remedy here.
That's the thrust. No remedy against the Senate President and no remedy against the Secretary of the Commonwealth.
Mr. Sachs, let me ask you this. As one looks at the Constitutional Convention and the briefs, and including the amicus brief, have been very helpful in laying out that. How does one address what appears to have been avoided? In other words, initially there was, what is called a sort of direct petition. It just goes straight through with no legislative involvement.
Regardless of legislative inaction.
Then there's a whole series of things about how you get majority votes. And then there appears to have been, let's put some brake on this at any event, that, you've got to get at least 25% of your elected voters to agree, otherwise you get endless, frivolous petitions going to the voters, and the voters, ballots are just clogged up. That, it seems to me, was not a break. I mean, it was a break on you have to get affirmatively the 25%, not a break on we can just stop every petition. If the Constitution doesn't contemplate that officers who are sworn to uphold the Constitution in fact don't do so, is there no remedy at all?
There is a remedy, and they did contemplate what would happen if the joint session didn't meet. First, the drafters contemplated that the governor could call them back into joint session.
Well, yeah, apparently he can't.
Here, apparently, he can't because they haven't adjourned, but that's what they contemplated. Now, I think both parties have quoted in their brief the statement of Mr. Quincy, one of the members of the 1917-18 convention, who said we don't need to consider what would happen if the joint session doesn't take action. But if he had gone on to the next sentence, would it have been because if they don't take action and the governor's power isn't sufficient, then surely the courts will order the legislature to take action? I don't think the convention would have adopted a role for the courts or envisioned a role for the courts.
I mean, I think it is not unreasonable, and I'm not here simply talking about, the legislatures in this case, but it's not unreasonable for the people in a democracy to assume that when a constitutional duty is clear, that it will be upheld. And so with respect to whether or not you think limits makes it clear, I choose to think that it is not clear to legislators, because if it were clear, they would abide by their constitutional duty. Is that not correct?
Well, this court can make it clearer. What the court cannot do, we respectfully suggest, is enter a declaratory or mandamus relief. And as the court said, in limits and in League of Women Voters, as it stated what the responsibilities of the joint session were, the court also said the remedy is at the ballot box if the joint session doesn't perform its responsibilities.
Let's go back to the clean elections case, where we got ourselves in kind of the middle of a ticklish situation, to put it mildly. Nobody thought there was much of a remedy there, but we said you have to vote on this because the initiative, or whatever it was, said you shall vote one way or the other. And then we ordered the sale of state property. Is there any analogy here that we could construct a remedy?
Well, what the court did not do in the Bates case, the clean elections case, is enter any relief directly against the legislature, first of all, and it's reaffirmed that principle.
Why could we not deem the vote to be a positive vote?
Yeah, and put it, have it certified by the Secretary of State.
Because that would contravene the language of Article 48, which says that an amendment requires 25% affirmative votes in order to be forwarded to the next legislature. And as this court said in the Mass Citizens case in 2003, I believe, absent an amendment's receipt of 1/4 of the affirmative votes of the joint session, Article 48 provides no authority for its referral to the next general court by the Secretary or anyone else.
Could we deem it to have been a negative vote, since there was no vote by 25%?
I don't think you need to deem it a negative vote.
Well, there already is a provision in the Constitution, in Article 48, for deeming a vote to have occurred, and it's with respect to legislative action as opposed to constitutional amendment. And that language does not appear in the constitutional amendment provision.
I would say that that's the effect of the Article 48 provisions regarding laws, that no legislative approval is required. There is, and I might say...
You just keep moving it along.
Yes, Article 48 is clearer.
That's citizens, correct? You just keep moving it along.
And Article 48 is clearer as to the legislature's responsibility as to laws than it is as to constitutional amendments. Article 48 says, it's Initiative Part 5, Section 1, a vote shall be taken upon the enactment of such law in the form in which it stands in such petition, period. No more, nothing like what appears in the sections about constitutional amendments, which is unless it's amended by 3/4 vote of the joint session and so forth. So Article 48 is clearer as to laws than as to constitutional amendments. But the intent of the drafters of Article 48 was very different as to laws. As to laws, they would go forward if they had the requisite level of voter support on petitions, regardless of legislative opposition or inaction, and that is citizens. On the other hand, in the case of constitutional amendments, the consequence of legislative inaction was very different, as this court said in the League of Women Voters case, and that difference was intentional. What the drafters meant to do was preserve some role for the legislature, but at the same time reduce what had been the problem under Amendment Article 9, which was that 2/3 of the House and a majority of the Senate, sitting separately, had to approve a proposed constitutional amendment.
If you are correct with respect to that, then in fact there is no obligation on the legislators to vote, because they can reasonably take the position, it seems to me. If that's your, interpretation of the difference between those two mechanisms of initiative petitions, then it seems to me that it's very difficult to say that the elected representatives have an affirmative vote to affirmatively vote on the merits of this coming through. If your interpretation is the constitutional amendments only went forward when one had affirmative legislative support, correct?
Well, Article 48 wasn't as clear as it could have been. This court made it clearer, I think, in the limits case and in the League of Women Voters case.
I am very hesitant to say that in fact it requires a vote on the merits if you are making a perfectly plausible argument that the Constitution is unclear and that it doesn't require it. And in other words, that a legislator could, consistent with his obligation or her obligation to uphold the Constitution, could vote to table, go into recess, or whatever, because your argument is unless and until you have legislative support, it doesn't go forward, as opposed to the other way.
That's not what we've argued in our brief.
I understand that, but I'm exploring what this position
There is
means.
an argument. There is a textual argument that there is no duty to vote, and that argument was made in the brief filed in the limits case in 1992.
And in any event, I take it, it is still easier to amend the Constitution through Article 48
Yes.
than it would have been under the predecessor
That was my
mechanism.
point. Article 48 substantially reduced the legislative barriers to a constitutional amendment. No longer do you need a majority of the Senate and two-thirds of the House sitting separately. Now all you need is a simple majority of the joint
But your
session.
argument doesn't make sense because what you have now said is that for some procedural rule, the legislature can simply stop it entirely, which it couldn't do under the old Article 9, I think, whatever it was, the original 19th century.
They could stop it entirely under Article 9. Now
They could stop it entirely,
they didn't have any obligation to vote on it under Article 9.
yes, and so essentially what the 20th century Constitutional Convention was trying to do was make it easier, but your argument simply says they can stop it entirely.
Well, the Article 48 has made it easier. It has reduced substantially the level of legislative support that's needed
It's supposed
to
to
move.
come all the way down to 25%.
Yes.
In practice, it has not.
What it has come down to is 25% of legislators who approve the amendment on the merits and an additional number to bring it up to a majority of the joint session who are committed to taking some final action, even if they oppose the measure on the merits. And there are legislators who believe that final action should be taken, even though they would oppose this particular amendment on the merits.
Could 25% of the members of the joint session on January 10th of this year, of next year, 2007, come forward and file a petition, a verified petition, saying that we constitute 25% of the elected members, that had a vote been taken, we would have voted in favor of submitting this to the voters, or whatever the technical requirement for a vote would have been. And then said we ask that the Secretary of State be required to place this issue on the ballot.
Well, it would be before the next session. I mean, let's assume, Justice Spina's hypothetical, but let's assume it's January 2nd. There's no votes taken. It just dies that evening. 25% of the legislature signs basically a statement saying, if a vote had been taken, we would have voted to send this on to the next legislative session.
Well, as Mass Citizens for Marriage said, absent a 25% affirmative vote by a joint session, Article 48 provides no authority for it to be referred to the next legislature by the Secretary or by anyone else. And presumably by anyone else means the clerk of the joint session, who under Article 48 is the one responsible for forwarding it to the next legislature if it is approved.
So in effect, I'm sorry, there is no judicial remedy. In the absence of a vote, of an actual vote at the joint session, it can't progress to the next level.
That's correct.
So the 25 minimum attempt to modify the tough requirements of the former Article 9 are meaningless.
They're not meaningless, Your Honor. The 25% approval requirement is still operative. What the drafters didn't foresee, they didn't have perfect foresight, What they didn't foresee is that one would also need a majority committed to taking some final action. If you have that majority, 101 legislators, then even if 51 of them are opposed to the amendment on the merits, if the other 50 are in favor of the amendment on the merits, then it goes forward. So the 25% approval requirement still has meaning. It's this additional need to obtain a majority willing to take some final action.
Was that legislators would be confused about this, didn't foresee that there would be this sort of lack of statesmanship as to how the Constitution was to be applied.
Perhaps not, Your Honor, and they didn't have perfect foresight. But the question for this court is there any judicial relief available? And the drafters did not intend to authorize a judicial remedy here. The drafters considered many other...
What do you say to the man or woman on the street who signed the petitions? Do they have any recourse?
Well, as this court said in League of Women Voters and limits their recourses at the ballot box. There are some, and as this court has said in other cases, relief is not always available for violation.
And wouldn't the clearest way to make it clear to the men and women on the street who signed the petition that they can't get anywhere for this court to do nothing and say it is the fault of the legislature, and so the people on the street who are disgruntled with what has happened know that what they can do is have a remedy at the ballot box?
Perhaps so, Your Honor. I think Article 48, and as already interpreted in limits and League of Women Voters, has made clear what the responsibilities are. The drafters, we don't contest what the drafters' intent was. Our position is that judicial relief is not available.
Do you think of any other instance where this court has said that a remedy for constitutional violations is to go to the ballot box, and if a majority of the people are still happy with having there be a constitutional violation, the Constitution can continue to be violated? It's an odd position to take.
Of course, League of Women Voters essentially was following up on limits and took that very position.
Still action
Two justices dissenting in Bates took the position that the remedy was at the ballot box, although the ultimate remedy endorsed by the majority there did not involve relief directly against the legislature, such as we saw here. But I think at the federal level, we've cited cases, the Colgrove versus Green case, where Justice Frankfurter said there are some issues, some constitutional requirements that cannot be enforced by the courts, and the ultimate remedy is at the ballot box.
And it depends on the fidelity of the executive and legislative branches. What does that mean? Some constitutional obligations are basically left to the fidelity. Fidelity to what?
Fidelity to the Constitution as a yardstick against which voters can measure their elected officials.
We do have other cases where we've looked at constitutional provisions and we say, in substance, they are basically precatory in nature, and the courts can't enforce them literally. It's up to the legislature to do it. We have lots of cases that say that, don't we?
I believe so, Your Honor, and I believe this is a case where the court cannot enter relief against the legislature or the secretary, and it should be left to the political process.
Thank you, Mr. Sachs.
All right.